Hello, everyone, and welcome to One Civil Law. And for today's story, we turn our attention to Harvard, which is currently in a dispute with the Trump administration relating to federal funding, particularly as it relates to alleged discrimination on the basis of religion and other sorts of illegal discrimination. So, as I'm sure you are more than familiar with, the Civil Rights Act provides that educational institutions, among other things, cannot discriminate on the basis of sex, religion, and other sorts of protected characteristics. This has been an issue at multiple universities, including Columbia, where the Trump administration tried to go after Columbia, but Columbia apparently folded on the issue. But Harvard so far is indicating they aren't going to fold on the issue, and they certainly have the financial resources to back up their play. They have a huge endowment, huge. So they can, in fact, go out without it for a substantial period of time. And so, we don't necessarily expect this to resolve quickly. But we're going to see what they're saying back and forth and try to adjudicate in some sense what we think is happening. And by the way, thanks for the compliment about the haircut. Literally just got my haircut like 20 minutes ago and just came in. So thanks for noticing. I appreciate it. We turn our attention to, first of all, the letter from the Trump administration. Then we'll read Harvard's letter of response, and then we'll read a lawsuit that is responsive to this. So first, we start with the Trump administration and what they had to say on the issue. This letter was directed to the president of Harvard. Dear President of Harvard, the United States has invested in Harvard University's operations because of the value to the country of scholarship, diversity, discovery, and academic excellence. But investment is not an entitlement. It depends on Harvard upholding federal civil rights laws, and it only makes sense if Harvard fosters the kind of environment that produces intellectual creativity and scholarly rigor, both of which are antithetical to ideological capture. Okay, so we have basically two theories of why we're trying to do this. We're trying to do this because we think you violate civil rights law. We're trying to do this because we think that you are not ideologically diverse enough. I'm not sure both of those reasons necessarily work legally, but let's read some more. Harvard has in recent years failed to live up to both intellectual and civil rights conditions that justify federal investment. But we appreciate your expression of commitment to repairing those failures and welcome your collaboration in restoring the university to its promise. We therefore present below provisions as the basis for an agreement in principle that will maintains Harvard's financial relationship with the federal government. If acceptable to Harvard, spoiler alert, it's not, this document will constitute an agreement in principle. With the parties will work in good faith to translate into a more thorough binding settlement agreement. As you will see, this letter incorporates and supersedes the terms of the federal government's prior letter. So this is, therefore, the new proposal, regardless of anything we've said in the past. This is the proposal to settle the case. Okay, fine. Governance and leadership reforms. By August 2025, Harvard must make meaningful governance reform and restructuring to make possible major change consistent with this letter, including fostering clear lines of authority and accountability, empowering tenured professors and senior leadership, and from among the tenured professorship and senior leadership, exclusively those most devoted to the scholarly mission of the university and commitment to the changes indicated in this letter, reducing power held by students and untenured faculty, reducing the power held by faculty, whether tenured or untenured, and administrators more committed to activism than scholarship, and reducing forms of governments, bloat, duplication, or decentralization that interfere with the possibility of reforms. I don't know what any of that means. It's all very vague, isn't it? As Harvard, I'm like, exactly what is it that you want me to do? Make changes that foster excellence. I don't quite understand what it is you want me to do exactly. It's very amorphous. Okay. Merit-based hiring reform. By August 2025, the university must adopt and implement merit-based hiring practices and cease all preferences based on race, color, religion, sex, or national origin. Well, this is a lot clearer. I understand what that means. Throughout its hiring, promotion, compensation, and related practices among faculty, staff, and leadership. I understand what that means, and some of that is just echoing the Civil Rights Act in the first place. Because discrimination on the basis of race, color, religion, sex, or national origin through hiring, promotion, compensation, related practices is already prohibited. You can't discriminate in employment. When we say discrimination in employment, we mean you can't discriminate on the basis of hiring. You can't discriminate on the basis of firing. You can't discriminate based on the amount of money you give them. And you can't also discriminate on them on the basis of sort of any incidentals that come along the way. So if you offer a benefit through the course of employment, whatever that employment is, a benefit is, it has to be offered on even terms, at least with respect to these categories. So, I mean, to make the most trivial example possible, like suppose you have a break room. Are you necessarily required to have a break room? Not in particular. But if you do have a break room, you have to make it open to everyone on the basis of race. That might be a silly example, but it might be an example that's not exactly money. It's not exactly compensation, but it's a benefit, right? So you have to offer any sort of benefit, training, perks, whatever, on equal terms relating to these characteristics. That's already the law. So that part I understand. $1.99 from Paris, Latino. Thanks for always for trying to be fair. I do my best. All existing and prospective faculty shall be reviewed for plagiarism. Holla. And Harvard's plagiarism policy consistently enforced. Fair. All hiring and related data shall be shared with the federal government and subject to a comprehensive audit by the federal government during the period in which reforms are being implemented, which shall last until at least 2028. I mean, fair enough. We think that you're not doing the things properly. We want you to share your numbers with us as basically part of a consent decree so that we can make sure that you're doing the things legally. This I understand a lot more. That's fine. Merit-based admissions reform. By August 2025, the university must adopt and implement merit-based admissions policies and cease all preferences based on race, color, national origin, or proxies thereof throughout its undergrad program, each graduate program individually, each of its professional schools, and all of the programs. Again, already the law, or supposed to be at least. Such adoption and implementation must be durable and demonstrated through structural and personnel changes. All admission data shall be shared with the federal government and subject to a comprehensive audit. And non-individualized statistical information regarding admissions shall be made available to the public, including information about rejected and missed students broken down by race, color, national origin, grade point average, and performance on standardized tests through the periods in which reforms are being implemented, which shall last at least until 2028. Again, broadly understand this. We think that you're not doing the merit-based enrollment in college. You are required to do that if you accept federal money. So, please do that and, basically consent decree. I understand this. During the same period, the dean of admissions for each program or school must sign a public statement after each admission cycle certifying the rules have been upheld. I mean, again, fair enough. Basically, we want your top level employee, basically for each of the colleges to certify that they're doing exactly this. I mean, fair enough. Admissions, international admissions reform. By August 2025, the university must reform its recruitment, screening, and admissions of international students to prevent admitting students hostile to American values and institutions inscribed in the United States Constitution and Declaration of Independence, including students supportive of terrorism or anti-Semitism. Okay, I have a bigger problem with that ideologically, right? I mean, people are entitled to their viewpoints, and whether or not the federal government has to admit those people into the United States is separate and apart from whether or not Harvard has to do anything. So should people that have those views be allowed entry into the United States? Probably not. That sounds like a bad idea for the United States, right? Why would we admit people into the United States who are hostile to us? They're not our citizens. Right? These are international students and they want to come to the United States. It's like, okay, but if you're hostile to us, why would we let you do that? That would be dumb, right? But assuming that for whatever reason, the administration gives them the visa or whatever, you want Harvard on top of that to do their own due diligence on top of the administration? I mean, Harvard has resources, but they don't have as many resources as the federal government does. They're not a law enforcement agency. They can't, do investigations and get records and, put people under oath. I mean, so what is it that you want Harvard to do that the administration isn't already doing? It's like, this feels more like an administration problem by the United States rather than an administration problem by Harvard. And to the extent that the administration is saying that despite these people's views, they're still admissible to the United States, You want Harvard on top of that to be like, no, we're not admitting them to our college, even though you, in this hypothetical, with full knowledge of their beliefs, decided they could still come to the United States. You want us to, on top of that, say, no, you can't come to Harvard? Why? Like, if they're good enough for the federal government, why would we step in? Right? That seems odd. And then also, of course, you want us to filter based on their belief systems, not necessarily their actions, which poses a whole set of problems for us, practically, on First Amendment terms, and a whole lot of other things. So this to me as Harvard, if I read this as Harvard, my response would be, this sounds suspiciously like a you problem, not an us problem. This sounds like a US government problem. If you don't want these people to come to the United States, don't let them come to the United States. But if you let them come to the United States, what exactly do you want us to do about it, you know? I mean, yeah, this doesn't feel like a Harvard problem. Harvard will immediately report to federal authorities, including the Department of Homeland Security and State Department, any foreign student, including those on visas and green cards, who commit a conduct violation. That doesn't make sense. I mean, if you're talking about, what do you mean by conduct violation? If by conduct violation you mean they violated the university's rules, the university can have rules that aren't even illegal, right? I mean, the university plagiarism isn't illegal, but they can still, like, you know, discipline you for it. So why would we tell the federal government about, like, academic misconduct issues? Because they're not illegal. So, and what are you going to do about it? Because it's not illegal. So what are you going to do about it? So that feels really weird. I don't approve of that. As above, these comprehensive throughout all of Harvard programs, enduring reform, shared with federal government for audit, shared on non-individual basis with the public, and certified for deans of admissions. Yeah, I can see it Harvard balking at that one. That's a little weird. Viewpoint diversity in admissions and hiring. Uh-oh. You want to make Harvard have viewpoint diversity in their hiring? Uh-oh. Yeah, we're going to run into First Amendment problems real fast. Real fast. Like, you want us to hire people. Yeah, I don't, yeah, no. No, that absolutely not. 100% no. By August 2025, the university shall commission an external party who shall satisfy the federal government as to its competence and good faith to audit the student body, faculty, and staff and leadership for viewpoint diversity. Man, I mean, could we any faster run into just headlong directly into the most aggressive First Amendment problems possible? Really? Viewpoint diversity? Seriously? Really? I mean, yeah. No. This audit shall begin no later than summer 2025 and shall proceed on department by department, field by field, or teaching unit by unit basis as appropriate. The report of the external party shall be submitted to university leadership and federal government not later than end of 2025. Harvard must also abolish all criteria, preferences, and practice, whether mandatory or optional, through its admission and hiring that function as an ideological litmus test. Federal government is going to lose. Federal government is going to lose. No. Every department or field found to lack viewpoint diversity must be reformed by hiring a critical mass of new faculty within that department or field who will provide viewpoint diversity. Each teaching unit found to lack viewpoint diversity must be reformed by missing a critical mass of students who will provide viewpoint diversity. Wow. If the review finds that existing faculty in the relevant department or field are not capable of hiring for viewpoint diversity, or that relevant teaching unit is not capable of admitting a critical mass of students with diverse viewpoints, hirings or admissions within department, field, or teaching unit shall be transferred to the closest cognate department, field, or teaching unit that's capable of achieving viewpoint diversity. This audit shall be performed in the same step taken to establish viewpoint diversity each year during the periods in which reforms are implemented, which shall be through the end of 2028. We were doing okay up until this point, federal government. We were doing okay, but no. Reform programs with egregious records of anti-Semitism or other bias. By August 2025, the university shall commission an external party which shall satisfy the federal government as to competence and good faith to audit those programs and departments that most fuel anti-Semitic harassment or reflect ideological capture. The first part, maybe. The second part, not so much. Anti-Semitic harassment? Oh, harassment is action. I understand that. Ideological capture, you're literally going after people for their ideas. Absolutely not. The program schools and centers of concern include, but aren't limited to, Divinity, Graduate School of Education, Public School of Health, Medical School, Religion, Public Life, FXB Center for Health and Human Rights, Center for Middle Eastern Studies, Carr Center for Human Rights at Harvard Kennedy, Department of Near Eastern Language and Culture, and Harvard Law School International Human Rights Clinic. The report of the external party shall include information as to individual faculty members who discriminate against Jewish or Israeli students or incite students to violate the rules. Maybe that's okay. If you're showing actual discrimination or actual incitements, like in the sense of Brandenburg, maybe that's okay. And the university and federal government will cooperate to determine appropriate sanctions for those faculty members within the bounds of academic freedom and the First Amendment. The report of the external parties shall be submitted to the university leadership and federal government not later than end of 2025, and reforms undertaken to repair the problems. This audit shall be performed and the same steps taken to make repairs every year during the period in which reforms are implemented. Discontinuation of DEI. The university must immediately shutter all diversity, equity, and inclusion programs, offices, committees, programs, initiatives under whatever name, and stop all DEI-based policies, including DEI-based disciplinary or speech control policies under whatever name. Demonstrate it's done so to the satisfaction of the federal government, and demonstrate to the satisfaction of the federal government these reforms are durable and effective through structural and personal changes. By August 2025, the university must submit to the government a report certified for accuracy that confirms it. Well, as to DEI, again, some of it may be illegal. Some of it may not necessarily be. If we're talking about discrimination on the basis of protected characteristics, already covered by law. So to the extent it's also not in the name, of course. The name doesn't matter. We can call it something else. It doesn't matter what name we call it. That's the thing. Like, we've seen some universities or some people try to get around this by relabeling it as, oh, it's not DEI. Let me give it some sort of magical different name, right? The label is not the thing. You guys know that. The label's not the thing. But that, of course, goes both ways. The label's not the thing. We can call it DEI, and at least in theory, it could be legal, because depending on exactly what the DEI office is doing, it might not be illegal. Just because we call it DEI, the label is not the thing, right? So what exactly are they doing? That's illegal. If they're doing those illegal things, they don't need to do those illegal things. But could you hypothetically have a DEI office that doesn't do any of those things, but does other things? Would it be possible in theory to have a DEI office that operated legally? Maybe. And then at that point, it doesn't really matter what we call it. Right? If you don't want us to call it a DEI office, I guess we can call it something else, but what's the point? The label's not the thing. So perhaps overbroad legally. Student discipline reform and accountability. Harvard must immediately reform its student discipline policies and procedures so as to swiftly and transparently enforce its existing disciplinary policies with consistency and impartiality, and without double standards based on ideology. That part makes total sense. Apply your own rules consistently. That part I understand. Where these policies are insufficient to prevent the disruption of scholarship, classroom learning and teaching, or other aspects of normal campus life, Harvard must develop and implement disciplinary policies sufficient to prevent those disruptions. This includes, but is not limited to, the following: Discipline at Harvard must include immediate intervention and stoppage of disruptions or deplatforming, including by Harvard police when necessary to stop a disruption or deplatforming. Well, again, as to deplatforming, Harvard is a private university. So they're not, as a university, as constrained by the First Amendment. They're private. They're not a public university. So Harvard can platform and not platform people basically on any basis it wants, including ideological reasons. They're private. So no, you can't have that either. We're allowed to deplatform people. We're private. We can do that. We have the technology. The fact we accept federal money only prevents us from doing certain things, which are specified in law, right? The fact that we accept federal money, and by federal money, this also includes, by the way, any sort of federal student aid. So basically, almost every university accepts federal money because it includes money to the student that's federal. So basically, any federal money. So Harvard does accept federal money. But that doesn't mean that they're suddenly a public university. It only means that they're not allowed to do certain things. For example, they're now covered by the Civil Rights Act, where they otherwise wouldn't be. So they're not allowed to discriminate on the basis of, race, national origin, so forth and so on. They're not allowed to do that. But that doesn't mean they're suddenly subject to the First Amendment in a broader sense. That's not how that works. Rodgas says if they're private, why are they getting taxpayer money? Yeah, for the reason I just said, right? By federal money, we mean any federal money, including to the students, for FAFSA loans, so, or Pell Grants or anything, all federal money, and so those among other things. But yeah, that'd be why. So let's see what else we got. Robust enforcement of and reinstatement of existing time, place, and manner rules on campus, including ordering the Harvard police to stop incidents that violate time, place, and manner rules when necessary. A disciplinary process housed in one body that's accountable to the Harvard president or other capstone individual, and removing or reforming institutional bodies and practices that delay and obstruct enforcement, including relative administrative boards and the faculty council. Harvard must adopt a new policy on student groups or clubs that forbids the recognition and funding of, or provision or accommodations to, any student group or club that endorses or promotes criminal activity, illegal violence, or illegal harassment, which, depending on exactly what they mean, that might be legal too. Right? I mean, again, like it is generally legal, and you have to be careful as you're dancing on the edge, because you have to be careful, but it is strictly speaking legal. It is strictly speaking legal to endorse or promote criminal activity, illegal violence, and even illegal harassment. You have to be careful about what exactly we're doing, but mere support of it, mere promotion of it is not illegal. So there's that. Invites non-students onto campus who regularly violate campus rules. Again, they're a private university, so whatever. Or acts as a front for a student club that's been banned from campus. I don't even know what that means. Leaders or organizations of recognized and unrecognized student groups that violate these policies must be held accountable as a matter of student discipline and made ineligible to serve as officers in other recognized student organizations. Well, now you're getting into what penalty academically. You're getting into academic issues. So if they violate Harvard's rules, it's up to Harvard in terms of how much they deal with that, right? So, I mean, if the only thing they're doing is violating Harvard's rules, then Harvard has the call by necessity. In the future, funding decisions for student groups or clubs must be made exclusively by a body of university faculty accountable to senior university leadership. In particular, Harvard must end support and recognition of those groups or clubs that engaged in acting anti-sectarian anti-Semitic activity since October 7th, 2023, including the Harvard Palestine Solidarity Committee, Harvard Graduate Students for Palestine, Law Students for Palestine, Students for Justice in Palestine, and National Lawyers Guilds, and discipline and render their ineligible officers and active members of those student organizations. That's also potentially too broad, right? Just because they're an officer in an organization that did bad things doesn't necessarily mean they did bad things. This isn't necessarily RICO. So, there's that. So just because someone's an officer doesn't necessarily mean they participated in it, encouraged it, or anything else. So there's also that. It's also guilt by association, which is a bit of a problem. Brad Gass says, imagine if a school in Texas was discriminating against diverse instead of discriminating on behalf, would we be having this conversation? Well, I don't know whether we'd be having this conversation or not, but I try to have the same viewpoint consistently because I always try to have the same viewpoint consistently. So if there was a Texas school that was somehow doing this in reverse and it came to my attention, I'd probably have the same opinion because that's usually how I roll. I try to be consistent. But thank you for your thing. Thank you for your comment. Harvard must implement a comprehensive mask ban with serious and immediate penalties for violation, not less than suspension. Harvard must investigate and carry out meaningful discipline for all violations that occurred during 2023, 2024, and 2024-2025 academic years, including Harvard School protests of October 2023, the University Hall sit-in of November 2023, and spring encampment of 2024. This must include permanently expelling the students involved in the October 18th assault of an Israeli Harvard Business School student and suspending students involved in occupying university buildings as warranted by the facts of the individual cases. I mean, again, to the extent we're talking about an actual assault, charge them, put them in prison, do that, right? But why are you imposing on Harvard to do your dirty work for you? If you're talking about an actual assault, like criminal assault, charge them, do that. But if you're talking about something else, right? And as to like the occupying university buildings, again, like you're talking trespass. But as to Harvard, how much they choose to care is up to them. If you trespass on my land, it's up to me to choose how much to care. Forcing me to expel you because you're trespassing is a weird take. I can, but do I have to? So that's a bit of a weird take. The Harvard president and police chief must clarify the Harvard University Police Department will enforce university rules and law. Harvard must also commit to cooperating in good faith with law enforcement. Whistleblower protections. The university must immediately establish procedures by which any Harvard affiliate can report noncompliance with reforms detailed in this letter. Any such reporter shall be fully protected from adverse action. I mean, fair enough as far as that goes. I think that's fair. Transparency and auditing. The university shall make organizational changes to ensure full transparency and cooperation with all federal regulation, not later than June 30th, 2025, and every quarter thereafter during the periods in which reforms are implemented, which shall include at least through the end of 2028. The university shall submit the federal government report certified for accuracy that documents its progress on implementation of reforms. To the extent that we're just trying to meet federal regulations that already exist, then fine, right? We want you to ensure compliance with the federal regulations. That feels like a fair thing to ask. The university must also, to the satisfaction of the federal government, disclose the source and purpose of all federal funds. Again, why? Right? I mean, is it legal for Harvard to accept that money? Maybe it shouldn't be legal. Maybe foreign entities shouldn't be able to give money to Harvard. Maybe that should be a law. We already have that with respect to campaign finance. Foreign entities can't give money for U.S. elections. And we've seen prosecutions relating to that because it's not allowed. So maybe we could do the same thing here. Maybe foreign money should not be allowed to come to Harvard. But if it's legal, then what do you want us to do about it? This feels like a U.S. government problem. Why are you putting this on Harvard? Cooperate with the federal government in a forensic audit of foreign funding sources and uses, including how that money was used by Harvard, its agents, and to the extent available, third parties acting on campus. Again, we're a private entity. What business is it of yours how we spend our money? We're private. You want us to open our books? I don't think so. Report on all requested immigration-related information to the U.S. Department of Homeland Security and comply with all requirements relating to some sort of system. We expect your immediate cooperation in implementing these critical reforms. Sincerely, the U.S. government. Yeah, some of that is problematic, and some of it is just blatantly illegal. So some of it is legal, some of it is questionable, and some of it, particularly relating to, we want you to ensure viewpoint balance, is just blatantly unconstitutional. Blatantly super unconstitutional. Totes super unconstitutional. It's hard to be much more unconstitutional in First Amendment land. You want to go after people and their viewpoint specifically? Holy shit, right? Holy shit. Yeah, that's a problem. All right, so Harvard has some thoughts that they'd like to share relating to this. So let's read Harvard's thoughts. Dear U.S. government, we represent Harvard University. We're writing a response to your letter. Harvard is committed to fighting anti-Semitism and other forms of bigotry in its community. Anti-Semitism and discrimination of any kind are not only abhorrent and antithetical to Harvard's values, but also threaten its academic mission. Well, I don't know necessarily that's 100% true. Harvard has a, let's say, questionable history when it comes to anti-Semitism. I'm not necessarily sure that it's completely purged from Harvard, but sure, you're committed. Let's go with that. To this end, Harvard has made and will continue to make lasting and robust structural policy and programmatic changes to ensure the university's welcoming and supportive learning environment for all students and continues to abide in all respects with federal law across its academic programs and operations while fostering open inquiry in a pluralistic community, free from intimidation and open to challenging orthodoxies, whatever the source. How many buzzwords can you fit into a sentence? Apparently, Harvard went with yes. Over the past 15 months, Harvard has undertaken substantial policy and programmatic measures. It's made changes to its campus use policies, adopted new accountability procedures, imposed meaningful discipline for those who violated policies. I question that. I'd like to see a little bit more about evidence relating to particularly that. Maybe it's true. Maybe a university has been imposing meaningful discipline. I'd like to know more, though. Enhance programs designed to address bias and promote ideological diversity in civil discourse. Also, I'd like more evidence relating to that, if you don't mind. Hired staff to support these programs and support students, change partnerships, dedicated resources to combat hate and bias, and enhance safety and security measures. As a result, Harvard is in a very different place today from where it was a year ago. I'm going to press X to doubt on that one. I'm sorry, Harvard. I don't believe you. Maybe it's true, but I'm going to need you to show a little bit more proof than totes. We're totes different, yo. These efforts and additional measures the university will be taking against anti-Semitism are not only the right thing to do, but critical to strengthening Harvard's community as a place where everyone can thrive. It's unfortunate that your letter disregards Harvard's efforts and instead presents demands that, in contravention to the First Amendment, invade universities' freedoms long recognized by the Supreme Court. Yeah, it does that. It does that very blatantly, very, very blatantly. The government terms also circumvents Harvard's statutory rights by requiring unsupported and disruptive remedies for alleged harms the government has not proven through mandatory processes established by Congress and required by law. No less objectionable is the condition first made explicit in the letter of March 31st, 2025, that Harvard accede to these terms or risk the loss of billions of dollars in federal funding critical to vital resource and innovation that has saved and improved lives and allowed Harvard to play a central role in making our country's scientific, medical, and other research communities the standard bearers for the world. Yeah, U.S. government, I need you to look up the term unconstitutional conditions, I need you to look that up. You cannot, in fact, say we're only going to give you money based on we want you to say the things we want you to say. You can't do that. It's an unconstitutional condition. You as the government can say, do you like money? And we're like, yes, we like money. But you can't say, you have to say what we want you to say. You might be able to say other things, but you can't say that. That is not legal. It's not even close to legal. You're going to get your ass handed to you in court, federal government. These demands extend not only to Harvard, but separately incorporated, independently operating medical and research hospitals engaging in life-saving work on behalf of patients. The university will not surrender its independence or relinquish its constitutional rights. Neither Harvard nor any private university can allow itself to be taken over by the federal government. Accordingly, Harvard will not accept. Harvard remains open to dialogue about what the university has done and planning to do to improve the experience of the community, but Harvard's not prepared to agree to your demands. Yeah, not surprisingly, because the demands are totes illegal. 100% totes illegal. All right, now let's read parts of this lawsuit. I'm not going to read it in full, but I'm going to skim it. From the American Association of University Professors versus the DOJ. And they'd like a TRO relating to some of this stuff. So we'll read through some of this to see sort of the highlights of the thing. Since Harvard is suing, what's the competent authority? The federal court is the competent authority. And what would the court's decision be? The federal government has to keep giving them the money. Yeah. They can't condition it on those reasons. If the administration tries to take this to the end, they're going to lose, at least in part, because those are unconstitutional conditions. So, yeah, that's the end of that game. This case involves an unprecedented threat from the Trump administration to withhold nearly $9 billion in federal funding to one of the nation's leading universities unless it cedes the changes that fundamentally compromise the speech rights. Yep. On April 3rd, defendants made clear that they would terminate, they did not meet to a litany of sweeping but vaguely worded demands. Also, that's true. Some of it was vague and unclear, and I didn't have any idea what they were talking about. Defendants have already canceled or frozen hundreds of millions of dollars in funding from other universities that have been targeted. Defendants' actions violate the law in numerous ways. Notwithstanding, defendants rely on Title VI of the Civil Rights Act to authorize their actions. Some of them, yes. They made no effort to comply with Title VI's statutory requirements or defendants' own regulations and procedures. Defendants never specified the ground for investigating Harvard, so the university might have an opportunity to come in compliance. So also, to the extent we're violating Title VI, there's a procedure for that, because of course there is. You know, the administration can't just snap its fingers and say, okay, no. $5 from Ann Bell Feinstein. Would it change if the foreign contributions were from North Korea, Iran, or other heavily sanctioned country? Again, I'm going to go back to what I said earlier, right? If the money is legal, what is Harvard supposed to do about it? If the money is illegal, it's already illegal. So what do you want Harvard to do about it, right? So you're not asking them to do anything. It's like, we don't want you to accept the money that's already illegal. Okay, it's already illegal. We're not allowed to do that. If the administration has reason to believe they're doing that in violation of law, then they can investigate that. If Harvard is in fact accepting illegal money, then, investigate them, sue them, prosecute them, and do whatever else is that you do with your time. But if it's like, we don't want you to accept the illegal money, we want you to agree to not accept the illegal money. Well, they're already required to not accept the illegal money. If the money is already legal, then what do you want us to do about it? It's already legal. So either way, it doesn't make any sense, but thank you for your super chat. Defendants have never specified a ground. They did not issue findings of noncompliance nor provide the opportunity to respond, nor have they explained how their demands or programs target for funding are linked to any noncompliance. These actions are in brazen defiance of legal constraints on Title VI. Yeah, exactly. I mean, amazingly enough, Harvard is in fact entitled to due process. That's basically the long story short of this thing. That's the long story short. Harvard's entitled to due process too. The government is giving them a benefit, the money. They'd like to take away the benefit because of Harvard fucking up on their end. Well, they have to go prove that in court, right? It's not necessarily beyond a reasonable doubt. It's not, but it's something, right? They have to give notice, opportunity to be heard, due process. We're familiar with this concept. And at this point, Harvard's like, we're not even 100% sure what it is exactly you think we did, because you haven't even given us notice about exactly what you think we did within the meaning of the law. So we're not even quite sure what we're being accused of exactly. So like, you haven't given us anything. I mean, that's a perfectly fair point, right? Michael says Congress can rescind the money. Of course they can. Of course they can, but they can't do it for some reasons. That's the thing. Congress, the government can do things for good reasons. Sometimes they can do it for no reason, but they can't do it for bad reasons. So can Congress say that we're no longer going to give money to Harvard? Yeah. Does that mean they necessarily can do it for any reason they want? No. They can't necessarily do it for any reason they want. But yeah, I mean, Harvard's not entitled to the money in the first place. So if the US government through Congress wants to pass a law and say, you know what, we're not going to give any more money anymore. We're not going to have the programs anymore. Fair enough. Fair enough. But, until that happens, what are we talking about? Right? It's sort of a silly comment, with all respect. It's at least in my opinion, it's a silly comment to say, well, Congress could cut off the funding. Yeah, maybe they can, but they haven't done that. So what are we talking about? Right? Let's stick to our current reality. If you want Congress to, take money away, talk to your congressperson. That's what they're there for. Maybe you'll get it. Let me know how it turns out. Isn't it already proven? No, absolutely not. 100% no. It's not already proven. Absolutely not. What exactly did Harvard do? What exactly are they being accused of? What notice that? No, that's a dumb thing to say too. No, we don't have any idea what you're talking about. We don't know what you mean. No, it hasn't been proven. No. Absolutely not. 100% no. No. As to having racially based admissions, well, yes, in the past, that's true. And the Supreme Court struck that down. It's not clear the degree to which they're still doing that, though. So in the past, did they have affirmative action? Yes. Of course they did. It was Students for Fair Admission versus Harvard. Yeah. So in the past, they had explicit affirmative action. The US Supreme Court struck that down and said that was illegal. Okay, are they still doing it? Are they still doing it indirectly? I don't know. Maybe. Maybe not. I don't know. You have to go show things. I don't know. That's what courts are for. Yeah. To say they must spend money is technically incorrect. Well, I didn't say they must spend money. I didn't say Congress is required to spend money. I did say that Congress can't stop spending money for certain reasons because those would be unconstitutional reasons. And Congress can't break the Constitution. So are you saying something I didn't say? Because I don't really like that when people say things I didn't say. It's like, yes, Congress controls the purse. Congress cannot spend money. That's their choice. But they can't make that choice for certain protected reasons. That would be unconstitutional. So I'm just saying. I didn't say anything different. Why are you saying things I didn't say? I don't like it very much. Someone else in chat? Oh, okay. So I don't know who's talking to who. Yeah, I don't know who's talking to who. So I was like, yeah, I didn't say that. But it is a pet peeve of mine. It's like I didn't say things. It's a big deal. Like, because I try to speak with precision. I don't always get it right. Sometimes I misspeak. Sometimes I don't say things correctly. And so sometimes I have to rephrase what I said. But, I try to speak correctly. And so if someone's like, you said this, and I'm like, no, I didn't. And that kind of pisses me off. If someone says you said this, and I'm like, oh, no, you're right. I did say that. I shouldn't have said that. Let me correct it. So I do that. And like, no, I shouldn't have said it that way. I should have said it a different way or something. But like, I don't like being held responsible for things I didn't say. Defendants' actions also violate the First Amendment. This happened recently also with the Karen Reed thing, because I was talking about the ARCA thing. And someone in the YouTube comments said, because I was saying, like, I was basically saying I never said something. And someone in the YouTube comments was responding to that by saying, wait until Kurt says he never said the ARCA experts would be excluded. And I said in the YouTube comments, I'm like, I don't think I said that. I don't think I said they would be excluded. What I remember saying was that it was being teed up that way. The questions from the judge were teeing up excluding ARCA. We were heading in that direction of excluding ARCA. That was what was being teed up. But I also had said it would be a very big decision to do because it's a huge deal. And it basically is inviting error, because it's a huge deal. The exclusion of the ARCA experts would be a huge deal. So can in principle the judge do it? In principle, yes. Would it be legal in principle? In principle, yes. But here is like, do you really have it? Are you sure? Because you're like inviting error. So this would be a big, big decision to do it. So they didn't exclude the ARCA experts. And I was like, yeah, that makes sense to me, because it would make sense. Because I'm like, yes, the questions are being teed up to exclude ARCA. That is what this is being driven to. That is what all these questions are being driven to. But also, it's a huge deal. And so they didn't do it. I'm like, okay, yeah. And then someone said, well, if she had done it, you would have said you were right because it was being teed up. And I'm like, yeah, you're right. If the judge had in fact excluded ARCA, I would have been saying, yeah, that's right. That's what was being teed up. I still would have said but I would have still said it's a huge decision. It's inviting error. It's a huge deal. So like, I'd be saying that this is an appellate issue for sure, but I'd also be saying, yes, it was consistent with the way things were being teed up. So I'm not quite sure what point that person was trying to make, but they felt like they were trying to make a point. And I'm like, I'm not quite sure what point you think you're making, but I don't know what it is. So it was very confusing to me. Yeah. So I just didn't know. I don't know. Yeah. Defendants' actions also violate the First Amendment. Yep. The administrative and policy changes defendants seek to coerce Harvard to undertake by holding hostage federal funds are stunning in their breadth, intrusiveness, and disregard for the fixed star. Defendants have declared entire programs must alter their curriculum to shift to the preferred viewpoint and ideology. Certain things must be shuttered. Yep. They can't coerce a private university into suppressing academic speech. Yes. By leveraging money. Yes. But this is unquestionably not what they're doing, not only to Harvard, but at least 100 other people. The Constitution forbids it. It sure, in fact, does. It 100% does. Yeah, no, not even a chance. So I don't know whether or not this TRO will be granted. I don't know whether it'll be granted in this case or some other case. So I don't know, where it's going to come, but it's going to come. It's going to come soon. It's going to come sooner rather than later. Because what they're trying to do is blatantly unconstitutional. blatantly. So, yeah. So let's see what else we've got in this thing. $10 from Dude McGuy. Kurt, I love your live streams a lot. Your perspective is always level-headed and fair. And I appreciate you being able to set aside feelings or personal beliefs and just give us pure analysis. Thanks. You're welcome. Not everyone appreciates it. Some people don't appreciate it. But I try. I'm flawed, but I try. Someone in Ian's chat yesterday was saying, well, it's hard to listen to Kurt because he gets so many of the facts wrong. I'm like, I don't think I do. I mean, my memory isn't necessarily perfect. Sometimes I make a mistake, but I think I'm okay. It's like, I think I get it mostly right. It's like, yeah. And if I do make a mistake, I'm happy to correct it. Like recently on Ian's stream, I was reading something. Someone sent me a thing relating to knives, and apparently it is legal for students to have a knife on their person that's less than 5.5 inches at school, at a K through 12 school, which I find to be amazing. But apparently it's legal. Now, as to the criminal law, now as to whether or not the school can ban it as a matter of their own policy, I don't know. That's a separate issue, but it's not illegal, which is interesting. So if the knife is under 5.5, it is not illegal. It might be an academic violation, but it's not illegal. Texas is a strange place, man. But apparently that's the law. And I still incidentally don't know from that how, if the knife was over 5.5, it means that he wasn't entitled to self-defense. I still don't know how they're getting to that, right? Because if it were a gun, he still could have the self-defense argument. Is having a gun on school property illegal? I'm pretty sure even in Texas. It's illegal for a student to have a gun. I'm pretty sure even in Texas it's illegal. But even if the gun is illegal, even if the knife is illegal, it still doesn't take away the self-defense argument, because it's a different argument. But we'll press on. We've frozen some fundings. The heart signs would be targeted. Blah, 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 blah. Yeah, like its predecessor, the letter did not identify any specific instances. It did not. The letter did not say anything specific. It was very vague and amorphous. Harvard's saying, we're not quite sure what you're accusing us of. I don't blame Harvard. I'm not quite sure what they're accusing Harvard of either. Thus, at the time of filing his motion, Harvard faces a possible choice: commit to the reforms, punish his favorite speech, and turn over hiring to policy preferences, or face imminent loss. Worse, this may be choice, as Columbia's experience demonstrates capitulating is no guarantee of avoiding devastating funding cuts. Yeah, blah, blah, blah. The legal standard is the same for a preliminary injunction. This court has jurisdiction. Each plaintiff has standing. We'll give them standing for the moment. We'll concede standing for the moment. So we don't have to get into that. They're not seeking money damages, nor do plaintiffs bring a claim sounding in contract. Yeah. Interesting. So whether or not this is money or not is an interesting aspect. Is this a suit for money? That's an interesting technical question. Is this actually a suit for money? Yeah, but it's not a contract. It's not a contract. It's kind of like a contract in some sense, but it's not legally a contract. It's different. So yeah, the Tucker Act probably doesn't apply. They're probably right. They violated the APA. They did. They failed to adhere to any of the procedures. They did. Yeah. The rules require the scope of any Title VI investigation be clearly stated so that there's a fair chance. The vague communications don't come close. No, they don't. Formal procedural prerequisites. Prior funding, they'd be required to prove they had an opportunity to be heard, followed by an express finding on the record, like they're entitled to due process. Yep. No findings on the record, tailoring of the sanction. The termination of funding must be limited to a part and must be limited in effect. So we don't even know, even assuming we're guilty, we don't even know if the sanction is tailored to our sins. So there's that. Just because Harvard did it bad doesn't necessarily mean you can yank all $9 billion. It might have to be a little bit more targeted than that. They're arbitrary and capricious. They pretty much are. No specific evidence of anti-Semitic harassment. They fail to explain it. Defendants provide no basis for the breadth of their threats. Blah, blah, blah. Reliance interest, that too. Fail to provide a basis for particular conditions. Yeah, blah, blah, blah. They're a final agency action. Probably. I mean, I'll concede that they're a final agency action for the moment. That sounds plausible. They're violating separation of powers and are ultra vires. Yep. They sure are. What else? They violate the First Amendment in so many ways it's hard to count. The unconstitutional condition. Yeah, so these lawyers know the phrase. I told you that the Trump lawyers were going to have to look this up because apparently they didn't know about unconstitutional condition. It's like, I know about unconstitutional condition. Yeah, you can't do that. The government may not place a condition on receipt of a benefit or subsidy that infringes on a recipient's constitutionally protected right, even if the government has no obligation to offer the benefit in the first place. Facts. Facts. Is the government required to give out food stamps? No. Is the government required to, do educational funding? No. They're not required to do it. But they can't condition it based on give up your constitutional rights, particularly and especially First Amendment rights, particularly those. Not so much. The government may define the limits of spending, but may not impose conditions that seek to leverage the funding on speech. Yep. And then this is very speech-oriented. It certainly is. It also targets Viewpoint specifically, which is a real problem. The government may not regulate based on hostility or favoritism towards underlying message. They certainly cannot. That's a problem. They violate due process in so many ways. The actions are causing irreparable harm. I believe it. The balance of equity supports the TRO, probably, and we would like to win. So yeah, I don't know necessarily whether or not this TRO will necessarily win, but some version of this from somebody's going to win. If Harvard themselves file it, they'll win. So if it was Harvard versus administration, if the caption was Harvard versus instead of these teachers versus, Harvard would win the TRO. No problem. No problem. And so they're definitely going to win some version of this. And then the Trump administration is going to, go into a tizzy about the whole thing. And they're not going to back down probably. And we're going to spend a couple years wasting on this issue. And Harvard is going to win in the end. If we go down this path, unless the administration changes its tune, right? They're going to lose, and they're going to lose big. So yeah. So all that stuff, no problem. Harvard's lawsuit is a winner. So let's read some of your chats and see what else you've been saying in chat along the way. And thank you for the 225 of you who are currently joining us. Paris Latino gave $1.99. Tony gifted 10 gift memberships. Annabelle Feinstein gave $5. Dude McGuy gave $10. Thank you for all those super chats. And let's take a look and see if there's any other chats from our members. Is Harvard saying they no longer have affirmative action DEI? I don't know if that Harvard is saying that or not. I didn't read that in their letter, but that's neither here nor there. Concerned trolls are the bane of our existence. I know. Law should not be political. Absolutely. I do my absolute best to keep it apolitical. I do my best. I'd like to think I do pretty good. It's capricious at best at the moment, yes. Radgas says, having just paid taxes, the fact this elitist leftist institution with a history of open racism is getting $9 billion is enraging. Yeah, I don't object to that opinion. Yeah, the fact that they're getting so much money from the federal government, I don't necessarily fault you for being enraged by that. $9 billion is a shit ton of money. You know, I don't know necessarily what Harvard is doing with that money. I don't know if it's a good value, but it is a lot. And so maybe we shouldn't be giving that amount of money to Harvard for other reasons, just like it's not a good use of our money. That would be a valid reason. See, this is what I'm saying, right? We don't want to do it because we don't think it's a good use of money. That's like a perfectly legitimate thing to say, right? Congress saying we're not going to give the money because we don't want to spend the money anymore would be perfectly legitimate to say, right? So like, yeah, that's a perfectly valid opinion, an opinion that I probably share more than I don't. But, you know, you can't just take it away for some reasons, and that's a problem. What's a concern troll? Google it. I don't want to take the time describing it, but Google what a concern troll is, and you'll understand better. All right, friends, I hope all is well for now. I believe that will bring us to the end of the stream. So if anything else that you guys want me to discuss, this came courtesy of someone on the channel suggested this exact issue. So this came from our Discord. This came from Paris Latino, as a matter of fact. Came from them on Discord. So thank you, Paris Latino, for providing the suggestion on our Discord. It is the best way to get in touch with me and bring its stories to my attention. And if something looks interesting, I may in fact cover it. So I hope you found this enlightening and exciting. Until later, my friends, I hope all is well. Cheers for now, my friends, and goodbye.